I'm often asked the question, what should I do if I'm stopped under the suspicion of driving under the influence of alcohol? Well, my short answer is do as little as possible. If you are stopped by the police, it is usually because they have a suspicion that your driving might be impaired. They notice something erratic about your driving. Perhaps it's speeding, maybe going too slow, or crossing over a yellow line. Whatever may be the case, when you are stopped under suspicion, chances are you're going to be arrested. This is because if they let you go and you get into an accident, and either you get killed or kill somebody else, they know they're going to be sued. And there are a multitude of cases to back this up. Therefore, after you have been stopped, the police officer, because he or she only has suspicion, needs to develop something called probable cause in order to make an arrest. Everything the police officer does from the moment he or she activates the blue lights is designed to develop that probable cause. And everything that you might do also will help them develop that probable cause. First, what you should do. The moment you see the blue lights activated, stop as quickly and as safely as possible. This is going to prevent the police officer from being able to say that you didn't obey instructions quickly enough, or that you almost hit 2 or 3 vehicles on the way to stopping. Also, prior to the police officers getting to your window, find your registration and license and have them in your hand. This will prevent the police officer from being able to testify that you weren't able to find your registration, you fumbled around, and basically that you did not have proper eye-hand coordination. And you are unable to follow instructions and being able to do that as well. Only open your window a very few inches. And when asked, hand out the license and registration. This will prevent the officer from being able to make that famous statement in court that when you opened your window, a strong odor of alcohol hit them. Remember, even if you've only had 1 drink, it might smell like you've had 10 drinks. The odor of 1 drink can be very damaging. If the officer asks you if you've been drinking, you may refuse to answer. You simply say, I don't want to answer any questions, officer. The Supreme Court a long time ago handed down a case in which they said that Miranda rights, those rights that telling you don't have to answer any questions, all right, are not applicable to roadside sobriety situations. Therefore, the officer is not going to tell you that you have a right to refuse to answer questions. I'm telling you that now. You may say, I do not want to answer that question. The worst thing you can say, by the way, is that I only had a couple of beers. Well, because I'll tell you why, there's not a jury in the world that believes it. So it's better to say nothing. If the officer asks you to step out of the vehicle, it is only a request. It cannot be an order. An officer may not order you out of a vehicle unless he or she has a suspicion that you have weapons on you. Therefore, you may refuse to get out of the vehicle. The officer is going to make it sound like an order, but remember it's not, and you may and should refuse. What you'll say to the officer is, your officer, I'm not going to get out of this vehicle unless I'm under arrest. Now, the officer might say the reason why they want you to get out of the car is to perform something called the field sobriety test. Do not take the field sobriety test. They are designed to make you fail. And by the way, in some states such as Massachusetts, the fact that you refuse to take a field sobriety test cannot be used against you in court and cannot be told to the jury. If the officer does decide to arrest you, there is another occasion in which you may be asked to take tests, and that is when you meet with the booking officer at the police station. The booking officer is likely also to testify against you, so be careful what you say to him or her, and make the same refusals to the booking officer as you made to the arresting officer. This includes the request to take a breathalyzer. Don't be mistaken in thinking that you could pass a field sobriety test or a breathalyzer test. The amount of alcohol under the new laws that is required to find you guilty of driving under the influence is so low now that they're going to take you to court even if you come near that amount. So don't do it. Now, the problem, of course, is once you refuse to take a breathalyzer test, you are going to lose your license for 120 days. But you know something? That's better than giving that damaging evidence to the police. And by the way, also, the failure to take a breathalyzer test cannot be used against you in Massachusetts and cannot be told to the jury. So look at the damaging evidence that you're not giving to the police officer. You're not making any damaging admissions, and you're not going to do this field sobriety test that you can't pass, and you're not going to take the breathalyzer test. I've never seen a case where there were no damaging admissions, no breathalyzer test, and no field sobriety test where the defense wasn't successful. Good luck. I know this is a scary proposition if it happens to you, but try to remember the instructions that I just gave you. Thank you.